another episode of OTA on the Air. With me today is Rich Pianka, who is the General Counsel with the American Trucking Association. So Rich, thank you for being on the show with us today.
Thanks for having me.
Well, obviously the first big thing that is obviously on everyone's mind was the Supreme Court's striking down the emergency action by OSHA on the vaccine mandate. I guess talk to us a little bit about ATA's involvement in that, what that means with the action by the Supreme Court and what the agency has done since then.
Yeah, so I imagine everybody is broadly familiar with what OSHA did in this so-called emergency temporary standard. They issued it in November. It basically required employers with 100 or more employees to, first of all, determine the vaccination status of their employees, and then they had a choice. They could either require their employees to get vaccinated, or they could require unvaccinated employees to test weekly and wear masks when in indoor spaces and in contact with others. So obviously a very wide-ranging rule that would have, that caused our membership quite a bit of concern for any number of reasons. Within a few days of them publishing the rule, we challenged it in the Fifth Circuit Court of Appeals. As an appellate court based in Texas, covering Texas, Louisiana, Mississippi. The way these rules are challenged is you go straight to a court of appeals. So that's what we did. And the Fifth Circuit very quickly imposed a stay on the rule. They expressed the belief that OSHA didn't have the authority to issue this rule, which was our argument, obviously, and therefore they imposed a stay of the rule while the litigation fully wound its way through the system. So shortly after the Fifth Circuit imposed that stay, the case was transferred to another court, the Sixth Circuit Court of Appeals, which is based in the great state of Ohio. They sit in Cincinnati. They cover Ohio, Michigan, Kentucky, and Tennessee. And the Sixth Circuit actually lifted the Fifth Circuit stay. They said that this is within OSHA's authority, that the challengers weren't likely to succeed in the course of the litigation, and therefore they lifted the stay. Within about an hour of that order, we were off to the Supreme Court with an emergency stay application to reimpose this stay. And the Supreme, also shortly after that, OSHA announced that it had pushed out the compliance deadlines by about a month or so to account for the period in which it was stayed by the Fifth Circuit. So that gave the Supreme Court a little bit of time to mull over the application for the stay. And they actually did a fairly extraordinary thing for the Supreme Court. They scheduled oral arguments on an emergency stay application, which is something that apparently they haven't done since the early 70s. And I think, shows the seriousness of this issue, obviously, and the national impact it had, that the ETS had. And there were about 14 or so challenges filed against the ETS, 15 or so applications for an emergency stay filed with the Supreme Court. Supreme Court chose 2 of those for oral argument. One, a case brought by about 27, I think, state attorneys general, and then ours, the case that we brought with a coalition of state trucking associations, including the Ohio Trucking Association, who joined us when we were transferred to the Sixth Circuit, which lives there, as well as the other state associations from the Fifth and Sixth Circuit states, and a bunch of other business groups who were also challenging the rule on similar theories to us. So we were one of the 2 groups of challengers chosen for argument, which I think is a reflection that we presented the case compellingly, and we made the cleanest arguments, queued it up in a way that made it easier for the Supreme Court to get traction on these complicated issues. And the other 12 cases or so, basically, they didn't feel that they needed to hear from those challengers. Oral argument took place a few weeks ago, shortly after the new year. It was a very long and interesting argument. Went on for almost 2 hours, which is also unusual. Usually they keep it to about an hour. And then we bit our nails for a while. We were expecting a decision very quickly. because the compliance deadlines were looming very quickly on, I can't remember now the dates. I want to say the 10th or so of January, I think, is when the first part of the obligations kicked in, the compliance obligations kicked in. We didn't end up hearing from the court until the 13th, so several days after that, which was a little bit frustrating and a little bit worrisome in some ways, because we were all figuring they would act quickly if they were going to stay the rule. But they did on that later in that week, a few days after the rule partially went into effect. They did stay the rule in an order that they issued a 6-3 ruling, in which they held that OSHA did not have the authority to promulgate a rule like this under its emergency temporary standard authority. And there were a bunch of different reasons that the court gave. I won't get any further into the weeds. I'm probably already deeper into the weeds than anybody cares to hear. But the important thing to know about the ETS is that even though this was technically a stay pending the outcome of the litigation, back in the Sixth Circuit, OSHA saw the writing on the wall, and just yesterday they withdrew the ETS altogether. So they're not going back to the Sixth Circuit to fight a futile fight. They recognize that the Supreme Court's opinion on it, even if it technically didn't kill the rule altogether, made it clear what the ultimate outcome here was going to be. So OSHA is not going to try and revive and fight for this ETS. The ETS is gone. The one potential wrinkle here, one thing to, the sort of, last frame of the horror movie where you think the killer's corpse is laying there and then the finger twitches or the eye opens as the camera fades to black. OSHA was treating this ETS as essentially a proposed rule for a permanent standard under its regular authority, which is actually something they have to do as part of the emergency temporary standard process. That rulemaking is, at least in theory, still alive. So it is possible that OSHA will try to promulgate some kind of permanent non-emergency standard relating to COVID and vaccination and testing and masking. Whether they will do so at all, I think is hard to predict. I mean, we all know how quickly everything is changing. We also know how long it typically takes OSHA to promulgate a permanent standard. It can take them years to do so. And obviously, there wouldn't be any point in doing anything like this on a 2-year time frame. So unless they could somehow get something out real quick, it's hard for me to see them, going down that path. Even if they do something real quick, I think they are going to have to account for what the Supreme Court said in our case. The statutory authority for a regular standard is a little bit different than the authority for an ETS. They have some greater discretion, but if they tried to issue a regular standard that looked like the ETS, I think they would know the outcome of a challenge to that would be similar here. The Supreme Court was pretty clear, I think, about that. So I find it hard to imagine that they would issue a standard that was as broad as the one that they issued under the emergency power. I think it's somewhat more likely that we will see potentially, I'm not predicting that this is likely, but if they issue anything, I think it would be something considerably more targeted than the ETS was, maybe targeted to specific workplaces, specific industries where the risk is particularly high. And hopefully if they did that, hopefully they don't release anything. If they release something like that, I think there's a decent chance that it won't affect the trucking industry very much, if at all. The ETS itself had a provision carving out employees who work exclusively outdoors or alone, as long as they only had minimal indoor contacts, like a quick trip into an office to drop off paperwork. So arguably, over-the-road drivers, or at least many of them, would not have been covered even under the ETS. If they issue a more targeted permanent standard, and again, we're not expecting them to do so, it's just a possibility. If they issue a more targeted standard, there's a decent chance that it would affect us even less than the ETS itself did.
Well, didn't the ETS also have a provision about healthcare workers that did allow for them to require that piece, or what was that little piece that was in there as well?
Yeah, that was actually that was a separate statutory authority and a separate agency. So what that case was about was the Center for Medicaid and Medicare Services, which administers the Medicare and Medicaid programs, obviously, had essentially said, hey, hospitals, healthcare facilities, if you want to continue to take Medicaid and Medicare funds, you need to get everybody vaccinated.
Okay.
So it wasn't OSHA, and it wasn't the same sort of statutory authority. It was really a condition on spending, a condition on a grant of funds under a statute that gives CMS some authority to regulate hospitals and healthcare as a condition of their funding. There was some question as to whether those statutes gave them this kind of authority, or whether it was more limited to more administrative things. And the Supreme Court upheld that one. The Supreme Court said that that was within CMS's power to require vaccination as a condition of continuing to take funds. So that's going to have a big impact, obviously, in the healthcare industry, because Medicaid and Medicare funds penetrate the healthcare system pretty pervasively. But that has no direct impact on the trucking industry. There may be a few cases where a trucking company has enough of a relationship with a hospital, if they're doing specialized work, it may touch them. But even that, I don't know that that's the case. I've heard, I haven't looked at it, frankly, very closely, because it's such a marginal issue for our industry. But it's possible that a company or two might be told by a hospital that they work with that, hey, if you're going to send drivers in here, they're going to need to be vaccinated. Hopefully not enough to be disruptive for the industry.
Yeah, well, thank you to ATA for your leadership on this and running point on this for everybody, and for including us in on the lawsuit. I think I was begging and pleading from get-go to be a part of this lawsuit, and when it hit the 6th, I was like, I definitely want to be a part of it. So definitely something that the ATA and the other associations do for their members to make sure that they're protected from this kind of overreach. So speaking of overreach, let's shift gears to a state issue. The state of Rhode Island and their tolling plan on the bridges in and out of there. I guess talk to us a little bit about where that lawsuit is at and what we can expect to see in that process.
Yeah, so just a quick little bit of background for those of you who don't know what Rhode Island's doing. Hopefully a lot of your members don't go anywhere near the state of Rhode Island. Rhode Island decided 5 or 6 years ago, 2016, that they were going to toll interstate highways using a loophole in federal law that allows tolling of bridges, even on federal aid highways, when they're being replaced or rehabilitated. And they took an aggressive position with respect to that bridge exemption. It's always been understood to relate to sort of massive capital projects like a river crossing, where you can understand, the need for an infusion of funds. Rhode Island decided that, a 2-lane overpass is a bridge. So they can, toll essentially any place they felt like tolling, because there's overpasses everywhere. And FHWA was okay with that, unfortunately. FHWA didn't have a whole lot of discretion over that. So anyway, they went ahead with it, and the crucial point, of course, is that they decided not to toll everybody. They decided just to toll Class 8, FHWA Class 8 vehicles or above, so tractors, semi-trailers, not straight trucks, and certainly not cars or buses. Despite the fact that we all know that, straight trucks can be just as heavy per axle as a tractor semi-trailer. Despite the fact that we know cars obviously contribute to the cost of maintaining bridges and roads, no question about that. You can argue about what the ratio is between a car and a truck, but you can't argue that they don't cause any damage. And the reason they did this was very clear. They wanted to shift as much of the burden of funding these projects onto out-of-staters as they could. And this was the way to do it. Okay, I mean, most of the trucks, Class 8 trucks, are overwhelmingly used in interstate commerce. And so if that's all you're taxing, or tolling rather, if that's all you're tolling, then you are going to hit out-of-state commercial interests much disproportionately as compared to in-state commercial interests. The Class 6, and 7 trucks that they had originally thought about tolling and decided not to are, your construction trucks, your utility trucks, your garbage trucks, that sort of thing, that are much more likely to be local in nature. So they essentially decided, well, we got a choice between, not repairing these facilities, doing something even-handed that's going to affect our own voters, or trying to foist the cost off onto others. And big surprise, they chose door number 3. The problem is the U.S. Constitution doesn't allow them to do that kind of thing. The U.S. Constitution vests the commerce power, the power of interstate commerce in Congress. And the implication of that is that states cannot unduly burden interstate commerce. And what that means in practice is that they can't discriminate against out-of-state commercial interests to try to favor their own people. For precisely this reason, if they could do it, if they could put their funding problems on the backs of people that can't hold them accountable, then they can do whatever they want. And if every state did that, it would be chaos. So that's why we brought this case. We've been fighting it since 2018. We're coming up on 4 years now. We've already been to the Court of Appeals on 3 different appeals, two trips involving 3 appeals. It has been a tremendous slog. Rhode Island is engaging in an absolute scorched earth campaign here. They've got anywhere between $40 and $60 million a year on the line in perpetuity, and it's worth it to them to do everything they can to stop us here. And that includes trying to just outspend us or spend us into the ground. So it has been an extremely difficult, fact-intensive, aggravating case against a defendant with bottomless pockets, essentially. We are finally, I am happy to say, sort of near the end of the tunnel. We have a pretty firm trial date in May of this year. We are at the end of our marathon, or getting near the end of our marathon. We're right now in a very busy phase of the trial where we are taking depositions of Rhode Island officials. And they are doing the same with us. We are getting all the last bits of sort of the factual development completed, again, for a trial in May. And we expect that we'll get a decision relatively quickly after that trial. So we're getting near the end of the road here. This is a very important case, obviously, even for folks like your members who I hope never pay a toll in Rhode Island, because we know, like I said, the whole reason Rhode Island did it applies everywhere else. If you can get money from people who can't vote you out of office, that's always going to be your go-to piggy bank. So we just can't, and that means trucks when it comes to highways, right? So we can't allow this idea that they can use us as a piggy bank to just go forward without fighting it to the death.
Well, yeah. And in our listeners' case, in our state's case, obviously the big one would be the Brent Spence Bridge, right? And so, that would be a scenario that plays out where if they are allowed to just do commercial motor vehicles, Class 8s only, that would really ease the argument from the folks in Northern Kentucky who are talking about commuters getting over that bridge and being able to build that. So yeah, I mean, the thing is this one hits closer to home than I think most folks in Ohio truly understand.
Yeah, I mean, it will spread like wildfire. We've already seen a number of states of all sorts, very geographically and politically diverse states who are looking at targeting trucks. Again, for this very reason, it's an easier political move to target trucks than it is to do something even-handed and sustainable. So Connecticut next door, maybe not a huge surprise, was considering truck-only tolls. They decided to hold off until this litigation played out. They did impose some bizarro other, truck-only pseudo weight distance tax that I don't even know what to tell you about right now. It's a strange beast. But we've seen states like Texas and Wyoming looking at truck-only highway funding, truck-specific highway funding, not tolls in those cases, but again, targeting trucks as an easy revenue source to avoid tough decisions that, unfortunately, under our system, states have to make those tough decisions, for better or for worse. They just can't burden interstate commerce like this, because if everybody does it, then everybody's going to be, every truck that moves through, all 50 states is going to be paying for those states above and beyond what they already do. I mean, we are not, this is not about us getting a free ride. We are the only vehicles out there whose fuel taxes and registration fees are apportioned based on where we're driving, right? I mean, we want to pay our fair share, and we want to see some of those fees increase to create a sustainable and fair way of funding highways. But the way Rhode Island is proposing is the easy way. It is neither fair nor sustainable, and we need to make sure it doesn't spread.
I agree. So one other case that is one that is all pun intended, kind of a sleeper, is one that you had posted about most recently on LinkedIn, was about the case about paying drivers for time in the sleeper berth. So I guess talk to us a little bit about that case, where it comes from, and what the impacts would be if this were to prevail.
Yeah, so this is a case where we filed what's known as an amicus brief, or a friend of the court brief, and ATA has a pretty fairly active amicus program, where if there's a case in a court of appeals or a Supreme Court that's going to set precedent on an issue the trucking industry cares about, we want to make sure that the court's not just hearing from the plaintiff and the defendant, they're also hearing from the industry, so that they know what is really at stake here beyond the two parties to the case. So this issue is about whether the Fair Labor Standards Act, which is sort of the basic federal wage law, the one under which everybody, gets a minimum wage of $7.25 an hour. In most industries, gets overtime if they work more than 40 hours, although obviously, commercial drivers who are working in interstate commerce have an exception to that. So the question is whether the Fair Labor Standards Act treats sleeper berth time as compensable time, or whether it's off duty for FLSA purposes, but assuming you're not actually working. I mean, the fact that you're in the sleeper berth isn't the crucial distinction. It's whether you're resting, doing your own thing in the sleeper berth, as opposed to doing paperwork or whatever for your employer. And for essentially the entire history of the FLSA, which goes back to 1938, nobody's ever so much as suggested that if you are asleep in the sleeper berth of a cab, or if you are watching, a movie on your iPad, or listening to the radio or whatever, nobody's ever suggested that that is compensable time under the FLSA until the last 10 years or so, when a particular plaintiff's law firm got a clever idea and decided to see if they could make it stick, and they started suing people on this theory. And the first few courts to get these cases said, no, it's always been the case that this stuff is not compensable time under the Fair Labor Standards Act, just as the industry had always understood it. But then in 2018, they finally got a court to bite. And I think a lot of folks heard about the case in Arkansas federal court. This, I think, was in October of 2018. It caused quite a bit of consternation in the industry because it was so different from the stable understanding we had of the regulations. And the court in Arkansas said, no, this is compensable time. It said there's a regulation under the DOL regulations, you can exclude up to 8 hours of that time per day from compensable time, but you can't just treat it as compensable altogether. So that, caused a fair amount of alarm. And shortly after that, two additional courts, one in Arizona and one in Massachusetts, came out the same way. So now we have a mix of authorities. We have about 4 or 5 courts who have said, no, this is not compensable time. And we've had 3 that have said, yes, it is compensable time. And, this case where we filed last week is the first time that this has really squarely gotten before a court of appeals. The plaintiffs who have been bringing these cases, I think, have been pretty canny about trying to keep it out of the Court of Appeals, because I think they know that there's a pretty fundamental weakness in their argument. So they would like to keep this uncertainty alive, because it gives them a lot of leverage when they file these lawsuits to try to convince people to settle. So happily, the carrier in this case in the First Circuit out of Massachusetts decided they weren't going to play that game. They were going to take it to the Court of Appeals. And they explained to the court themselves very clearly why the regulations mean this time is not compensable. And we came in and talked a little bit about the history and how stable this understanding has been for literally 76 years or so, and hopefully, added to the motor carrier's case there, and explain really the chaos that would ensue. Now, just one quick thing to point out: the outcome of this case, it's certainly important, but it is not necessarily, the issue is not quite as far-ranging as it might sound. The way the FLSA works is you determine whether an employee is getting enough money by taking their total compensation for a pay period and dividing it by total number of hours worked, and seeing if that is 725 or above. Now, when you're talking about most drivers, if you've been dividing by 14 hours on the assumption that the 10-hour sleeper birth period is non-compensable, and it turns out that 10-hour period is compensable, but you can exclude 8 hours, well, now you're dividing by 16 instead of 14, and you're probably going to still be above 725, certainly with an experienced driver. But there are groups of drivers, particularly brand new drivers or driver trainees, who are, essentially paid on a minimum wage basis on the assumption that they're working 14 hours a day. And if the denominator switches in those cases, that's where you suddenly accrue a lot of liability. So there is a lot at stake here. But what's at stake is not necessarily, going to affect everybody in all classes of drivers. And one other caveat to keep in mind is that this is just about federal law. State law can be different. I don't think Ohio is radically different, if at all, than federal law, but states like, guess what, California, compensable time can be much different than under California law than under federal law. So even if this case comes out the way it should, and I expect it will, and sleeper birth time is not compensable under federal law, it may be compensable under the law of a state in which you're operating. So you need to be careful of that. And those states might not have this 8-hour exclusion that federal law has. Right. So there it can be very serious. And there has been some movement in West Coast states in particular to bring these kinds of cases under state law. So keep an eye out on that.
Well, I appreciate you giving us an update on those cases. Let's talk a little bit about the ATA Lit Center and the Litigation Center. Talk a little bit about what that is, what it does, and how it generates its dollars to do the work that it does.
Yeah, no, thanks. I appreciate the opportunity to talk about the Lit Center, which is something that's, not as high profile, I guess, as ATA itself, and a lot of folks don't know much about. The ATA Litigation Center is a separate entity, separate 501c6 advocacy organization that's affiliated with ATA, obviously, and shares staff, namely me, with ATA. In addition to being general counsel of ATA, I am the chief counsel of the ATA Litigation Center. And the ATA Litigation Center is essentially a public policy law firm that represents ATA and sometimes its members, if they are also parties to a suit, in cases of public policy interest to the trucking industry, whether that's the Rhode Island case that we bring ourselves, or whether it's this sleeper birth case I just talked about, where we're filing an amicus brief, a friend of the court brief. It's the ATA Litigation Center that does that work. We are responsible for the advocacy, the trucking industry's advocacy before the third branch of government, the judiciary. ATA obviously itself is focused on the regulatory agencies in the executive branch and Congress, the legislative branch, but we don't neglect the judicial branch either, since a lot of important legal matters that affect the industry get decided there. The ATA Litigation Center is funded to some degree by ATA itself, but also by contributions, the same way some of the other affiliated organizations that ATA has in its federation are funded. So we do rely on contributions from members and even from non-members who feel that they have a stake in our work. The idea behind the Litigation Center is to litigate issues that are going to cost everybody something, but nobody enough to actually bring it on their own. Okay, so the Rhode Island tolls is a good example. I mean, that's going to cost everybody in the industry something, especially if it spreads, but not enough for them to go to court and spend the kind of money we're spending to try to kill it. But if we pool resources, and that means accepting contributions from motor carriers and allied companies, if we pool those resources, then we can do it on behalf of the entire industry. So that's the function of the Litigation Center. We also have an educational mission. We host every summer, we host a legal forum over the course of 2.5, 3 days, which brings together mostly lawyers from motor carriers, but also safety folks, HR folks, CEOs who want to get a better idea of what's going on out there in the legal landscape as it affects trucking, so they know what kind of risks to be alert to, what kinds of things to think through with their lawyers, whether they're in-house or outside lawyers. So we do that every summer. We do a webinar series about once a month on various topics to educate the membership about, legal issues that are affecting trucking these days. And we are also very involved in ATA's lawsuit abuse campaign. That's sort of a joint effort of ATA and the Litigation Center. since obviously highway accident litigation is a litigation matter. So we work very closely with the ATA advocacy staff on developing a lawsuit abuse reform strategy and lobbying for that at both the federal and in conjunction with our state associations at the state level, working closely with the state associations to find opportunities to improve things at the state level, which is where most of the lawsuit abuse reform stuff, unfortunately, or fortunately, as the case may be, has to happen at the state level. These are state law matters fundamentally. So we work very closely with state associations like you to do what we can to help move the ball in the state legislatures. We also recently introduced, we didn't introduce it, a couple of members of Congress on a bipartisan basis introduced legislation that we have been promoting, introduced in December of last year, called the Highway Accident Fairness Act, which really, to our knowledge, is the first time Congress has considered legislation targeted at the trucking lawsuit abuse situation as opposed to any kind of more general tort reform. Congress doesn't do a lot of tort reform, again, because it's state law stuff. But this Highway Accident Fairness Act would help ameliorate the problem to some degree by making it easier to get these cases into federal court as opposed to state courts where the trial lawyers can run rampant over any sense of justice and fairness, and also would require disclosure of third-party litigation financing involvement, which is a horribly distortive influence on fair resolution of highway accident claims. We're not asking at this time for Congress to regulate that, but we need to shine some light on it. We need to see what the extent of the problem is, so and parties need to know what they're dealing with. So I think that's very important, and it would also establish a federal crime for staging an accident with a commercial vehicle, which we think is important. We've all probably heard, I'm sure all your members have heard about what has been happening in Louisiana, this insane ring of dozens of lawyers and doctors and other folks who are deliberately colliding with trucks to try to shake them down for money, and people performing surgeries unnecessarily to run up damages. Just an insane scenario where a number of people have been indicted under RICO for conspiracy. But we think there should be a federal crime specifically about this kind of thing. It's obviously not limited to just Louisiana. It happens everywhere. And there need to be more incentives against it, because it's not just unfair to the motor carriers, it's terribly dangerous to everyone. I mean, the idea of deliberately staging an accident with a big rig is it's bad for everybody. And so we think it's very important that Congress address that.
Well, good. Rich, thank you again for being part of this, and congratulations on your promotion at ATA. Well deserved. You've been a huge advocate on behalf of the industry for many years, and a wealth of legal knowledge that I often enjoy arguing with, and unfortunately lose too often. So one of these days I'll go to law school and get a law degree, and maybe have a fighting chance against you.
Don't go to law school. Nobody should go to law school.
All right, Rich, thank you again for being with us on OTA on the air, and to our viewers, tune in to this episode and all the others that you can view in the past. We're on, I think, episode 38 or something like this now. So Rich, again, thank you, and have a great day.
Thanks for having me. Take care.